Yeah, hi. Good morning, everyone. So I hope I am audible. So today we begin with a very interesting aspect of the entire aspect of how exactly to execute a final order or judgment or decree which has actually come into your favor. Now, we have obviously looked at this entire session from the point of view of executory orders or decrees. Now, before I come to the specifics, what exactly are we dealing with today? We are dealing today with a particular order or decree or judgment or any direction passed by a competent court of law, which is then sought to be enforced by the party in whose favor that particular adjudication has been made. Now, we will be primarily speaking today about the aspect of execution of decrees, because this is essentially what the CPC contemplates, right? A decree which is passed at the end of a trial. But before I go to execution, please bear in mind there are two ways or two different genres of enforcement which the Indian legal system, in that sense, recognizes. See, when it comes to civil decrees in the sense of, say, a decree made by a civil court or, say, by a tribunal or forum is usually subject matter of execution proceedings. For instance, there is a civil suit. At the end of it, you get a decree. You are entitled to execute that decree. You have an arbitration award in your favor by dint of the legal fiction under Section 36 of the Arbitration and Conciliation Act. You are entitled to execute that award as if it were a decree. This is as far as execution is concerned. But a more simplistic kind of enforcement is resorted to in the case of writ petitions. Now, let's say you file a writ petition against a certain entity. Now, writ petition is obviously invoking the extraordinary jurisdiction of the High Court concerned. It's the invocation of a constitutional power. Now, if a order is passed in the context of a writ petition, then to enforce the writ petition, you don't file an execution proceeding. You file a contempt proceeding. So please understand the difference between these two overarching methods of executing orders or enforcing orders of the court. If you are contemplating enforcing an order which has been passed in a pure civil proceeding, which does not invoke extraordinary constitutional jurisdiction, then you will execute that particular direction. If, on the other hand, you have succeeded in, say, something like a writ petition, or succeeded before any forum where the rules in fact provide for a contempt jurisdiction, then you will simpliciter file an application or a petition for contempt against the concerned authority before the High Court, praying that the requisite action be taken against the concerned officials of the authority or the person himself, the individual himself or herself, if the direction is directed against an individual. And it is through the contempt proceedings that you will effectively seek enforcement of the order or the direction passed in that particular writ petition. So, as far as contempt jurisdiction is concerned, it's relatively straightforward. You must have a order or direction which is specific in nature, which is time bound, which requires a particular set of actions to be performed or a particular set of actions to be eschewed by the counterparty, and which you will seek to enforce by filing a contempt petition before the High Court. And the way of enforcing the petition is that the High Court will take appropriate proceedings of contempt against the person if he or she does not comply with the order as is required. So please bear in mind that is contempt jurisdiction. But what we are primarily concerned with today, and that is because of its relative complexity, is the execution jurisdiction in the sense of decrees or civil decrees. Now, when we come to enforcement, as I already mentioned to you, we can file an enforcement at two stages. One, once the original court or forum renders a judgment or decree in your favor, Now, as I mentioned to you, though of course the other side has the right to go in appeal, as long as that particular decree or judgment is not stayed, or as long as that particular decree or judgment has not been interfered with, you can immediately seek enforcement of that particular judgment, subject, of course, to the judgment debtor. Now, this is the terminology we use. The person whose favor the decree has come in is referred to as the decree holder. The party which has lost and which is being proceeded against is termed as the judgment debtor. Now, subject to the right of the judgment debtor to go in appeal, and as we discussed in the last session, when he or she goes in appeal, they have a right to ask for stay of the impugned decree, subject, of course, to certain terms as the court may deem fit. So, therefore, when you file an enforcement, you are the decree holder, the other side is the judgment debtor. Now, this is one circumstance. The other circumstance is once the judgment debtor has exhausted all remedies possible under law. Let's say he files an appeal, he files a second appeal, he goes all the way up to the Supreme Court in a special leave petition, everything is rejected, and the ultimate decree ends up being final and in your favor without any modification, or even if there is a modification, to the subject to that modification. So that is the stage at which you will file an enforcement petition. Now, please bear in mind one very, very crucial aspect. Enforcement petitions have their jurisdiction in the sense of territorial jurisdiction determined purely by the situation of the assets of the judgment debtor. What does this mean? See, when we spoke in the very initial stage about how do you determine what court to approach, what are the parameters we looked at? So we looked at cause of action, where has the cause of action arisen, where is the agreement signed between the parties, possibly where does the defendant reside, where was the work to be done under the contract, etc., etc. So those are wide parameters. But now you've gotten an enforcement in your favor. Now let's go back to the A versus B example. A finally gets a decree in his favor saying there was a binding contract, therefore B must pay him 1 crore rupees. B goes all the way up to the Supreme Court. Ultimately, the Supreme Court in its judgment says that no, it is not 1 crore, it is 75 lakhs. So now the 1 crore is gone. The decree will be executed, the decree of the original court, subject to the modification that the amount will now be read as 75 lakhs. So far, so good. Now, let's say the original court before which the execution was filed is situated in Delhi. Now, naturally, the original court before which the actual proceedings were filed will be the court which will execute the decree. Because the court itself, which birthed the decree or which actually passed the decree, is the competent court to ensure that it is enforced. But this is the simplistic way of looking at it. Once you file that enforcement before the court, enforcement is not automatic. Why is it not automatic? Because for enforcement, you also have to determine where the assets of the counterparty are situated. Now, let's say B, for all practical purposes, doesn't live in Delhi. Let's say B lives in Bombay. B has 2 houses in Bombay. B has, let's say, investments in certain commercial properties in Bombay. So for all practical purposes, B's assets are outside the jurisdiction of the Delhi courts. Because Bombay has a different system, in the sense, not a different system, but Bombay has its own judicial setup in the sense of the Bombay High Court, the subordinate courts, etc. So therefore, under the CPC, ultimately, even though you filed that enforcement before the Delhi court, which actually passed the original decree, you are required to then seek a certificate for transferring that decree for enforcement before the court in Bombay, within which's jurisdiction the assets of B are situated. So always remember, even though it is the court which passed the decree before whom you must seek enforcement, always bear in mind, if the assets of the judgment debtor, not a single asset of the judgment debtor, is situated within the territorial jurisdiction of that court, then you are required to seek a transfer of the decree for enforcement purposes formally by that court to another court which has jurisdiction in terms of the situation or the or the subject matter of the assets being within its territorial jurisdiction. Now, even if one asset of B is situated within Delhi, to that extent, the Delhi court will be able to take jurisdiction, and then you can obviously file applications, etc., for detention in civil prison, etc., which we will come to later. So, therefore, always bear in mind the issue of execution as far as territoriality is concerned is very distinct from the parameters for initiating the original action. So please bear this in mind, because there's a misconception that execution also, the jurisdiction for execution also proceeds on the same premise as the actual, let's say, determination of where exactly to file the original proceeding. Now, these are aspects which are fundamental, which you must bear in mind. Now, to take you through what exactly execution contemplates in the sense of its different complexities or nuances, so I had uploaded two reading materials, two articles, which were written, which are written by judicial officers, and give you a very broad overview of how exactly execution functions. Now, there are two uploads. One is Execution Overview 1, which we will go through now. Execution Overview 2 is something you can contemplate reading up in your spare time, because Execution Overview 2 is specifically linked and specifically deals with each and every provision of the law in the sense of the specific sections, what they say, and the specific orders under the CPC and what they contemplate. So that is something which you can do to further augment what exactly is what is the understanding of the concept of execution in a statutory fashion. But for the purpose of today's class, I think it will be better if, instead of just going through the provisions, we actually embark on more of a thematic review of what are the different elements in an execution proceeding. And for that, I think the better standpoint is the Execution Overview number 1, which I will now just be sharing, and then we can go through it one by one. Right. Yes. Now, I hope this is on the screen before all of you. So see, as I had mentioned to you today, execution is basically the culmination of the entirety of the process which has preceded it, in the sense of the efforts put in by the parties to articulate their respective cases before the court through the variety of pleadings, affidavits, cross-examination, submissions, etc., and ultimately resulting in the decree or judgment which has now been passed by the original court concerned. Now, as I mentioned to you, the court concerned which has actually rendered the judgment is the court which is required to execute it. Now, in exceptional circumstances, say there is an obliteration of that particular court because of, say, certain revamp in the judicial structure, or the particular judge who has passed it is unavailable, etc., etc., then in those circumstances, the implementation can be done by another court which has competency to do the same, possibly in terms of pecuniary jurisdiction, subject matter, etc., etc. Now, as we mentioned, execution is nothing but enforcement. It is a way of ensuring that you are able to reap the fruits of the decree or the judgment which has been passed in your favor. So in the context of A versus B, A is now able to ensure that the amount of rupees 75 lakhs which he has been held entitled to recover can now be so recovered by him from B, who otherwise might be recalcitrant and may refuse to pay the same. Now, as we also spoke about in the morning, see, one important aspect of execution is that this is also the culmination of this entire rule of law paradigm, because it is not just a question of being able to have your rights adjudicated, but it is an equally important aspect of being able to get those rights or those adjudicated rights enforced, right? Because as we say in that common adage that the proof of the pudding is in the eating. So ultimately, you may have, let's say a super fast adjudication, you may have a brilliant adjudication, and justice may prevail in the sense of the decree or judgment which you are the beneficiary of. But ultimately, if you are unable to execute, then what really is the whole point of actually having gone ahead with that particular process? Because ultimately you are left then with the paper decree or a completely academic exercise in the sense of the validation of your rights, without actually any concrete follow-up action being taken to actually vest you with those rights. So this is why execution is so important, not just in the procedural sense of things, but also normatively in the sense of the strength of the judicial system as a whole. Now, one important aspect, and this is what a lot of practitioners rue, and there are a lot of memes and jokes about this, but the sheer length of Order 21 of the CPC, which deals with execution proceedings. So now this is the lengthiest order in the CPC. Now, as all of you know, in the CPC, actually on the practical level, when you actually come down to it, it is the orders which actually dictate how process or procedures have to be followed. The sections in that sense are more substantive. They essentially deal with the basic fundamental underlying principles, but it is these orders under the CPC which essentially lay down the exact procedure or the exact methodology which is to be followed in that particular process. Now, therefore, in the case of execution proceedings, this order 21 is the lengthiest in the CPC, and it is really, it is not really very easy in terms of a read, which is why I said that the other reading essentially breaks it down for you and possibly makes it easier to deal with the length of this order and the various elements which it seeks to implement. Now, obviously, an execution petition also is not something which is rendered or which is taken up suo motu. No court is going to suo motu call upon parties to say, please execute my civil decree. Right. So therefore, ultimately, it is the party in whose favor the decree has gone, the decree holder, which must initiate such an action and file such an execution petition. Now, considering it's an independent petition, once again, we go back to that the entirety of the aspects which we must bear in mind. It must be drafted properly. It must be concise. It must have the exact description of what are the properties, what are the assets you are seeking enforcement against. You might file interim applications asking for stay of the judgment debtor, trying to, let's say, in any way dissipate the assets. So the entire rigmarole, which is applicable, say, to an original proceeding in a certain more limited manner, is obviously again applicable to an execution proceeding, including elements like court fee, etc. Some states may have, different states may have different court fees which you are required to pay, possibly to execute the decree. Again, that depends from place to place. Therefore, this is something which you need to bear in mind, that it is an independent petition or enforcement application which you are required to file. It's not merely a question of filing, say, an interim application in that suit which actually got decreed. For all practical purposes, that suit proceedings are over. What you are left with now is a decree which you must independently enforce through the means of an independent execution petition. Now, who all can file execution proceedings? So, as is the normal course of things, of course, the decree holder. If the decree holder has passed away, then his legal representatives, possibly a representative of a person claiming under the decree holder. Some legal representative may again further grant power of attorney to some other entity, and in some cases, a transferee. For instance, A decides to A articulates the claim against B in terms of the company or in terms of a sole proprietorship of which he is the owner of. Now, by the time the trial is conducted, by the time the decree comes, by the time it reaches all the way up to the Supreme Court, A decides to retire from his business. So a C comes up to him and says, I want to buy out your business. So evidently, when A is selling his business to C, he will be transferring all assets and obviously be expecting a corresponding return in terms of the consideration from C, which would include something like a decree in his favor. So therefore, once the business as a whole is sold by A to C, to that extent, if there is an express provision for that in the transfer deed or transfer agreement, C will then become the transferee of A. as far as that particular debt or as far as that particular enforceable debt in the form of the decree is concerned. So these are the persons who can actually seek to enforce the decree. Now, who exactly can execute? Now, as I already mentioned to you in the beginning, under section 37 and 38 of the CPC, the court which actually passed the original decree is the court which is actually the executing court. Now, as I mentioned, if we had assets, say, in Delhi, and let's say the district court at Delhi passed the decree, then you would simpliciter go before the district court and prosecute the entirety of the execution there. But if, for instance, there are no assets within the jurisdiction of the Delhi district court, then you are going to ask for a transfer of that decree by the Delhi district court to the competent court within whose jurisdiction this particular assets may lie. Now, therefore, as I mentioned to you, merely because there is a transfer of the decree does not in any way efface the validity of the decree. Because the executing court at Delhi is going to give you a certificate saying, this is my decree, this is passed under my sovereign power. Now, I hereby authorize you to go and file this decree before so and so court, which you claim is the authorized court in terms of the situation of the assets of the judgment debtor. Now, therefore, the ultimate aspect is that the court concerned should be able to exercise jurisdiction over the judgment debtor. And in the context of execution proceedings, primarily this means the assets of the particular entity. Now, if the if the judgment debtor is an individual, possibly where he or she is situated, you might still be able to maintain an execution proceeding, because you may try and resort to aspects such as, let's say, detention in civil prison, etc., which we will come to. But when it comes to companies, etc., essentially because the company is a separate legal personality, merely because the company is possibly situated in a particular place may not be sufficient if all the assets of the company are situated elsewhere, in which case you will definitely have to move the court within whose territorial jurisdiction the assets are situated. Now, what are the modes for execution? See, as I had mentioned to you, contempt proceedings are relatively simple, because the court is going to ask for enforcement of its direction or, let's say, order passed in the writ. And if there is failure to comply, the standard methodology available under the Contempts of Courts Act is to actually find the judgment debtor guilty of contempt and then proceed to apply the necessary punishment, which can range from fines to imprisonment. So that's a relatively simplistic process, and that is something which the court will take up on itself. And that is also more simplistic because always remember, under contempt jurisdiction, there is a range of case law which has explained this jurisdiction to mean that contempt is ultimately between the court and the alleged contemner. So what this essentially means is that once you've intimated a writ court, or once you've intimated the contempt court that a writ order or something similar has not been adhered to by the counterparty, then effectively the case law seems to suggest that beyond that, the petitioner doesn't have much of a role, and then the court takes up on its own onus to ensure that its decree, its writ order is actually complied with by the contemptor, and therefore the onus then in that sense is something which is being exercised by the court itself, and the petitioner to that extent doesn't really have that involvement anymore. But of course, you continue to remain a party, you continue to obviously press for adverse orders against a respondent, but jurisprudentially the judgment seemed to indicate that the court then takes up this on its not suo moto, but the court then takes up the onus once this has been brought to its notice by the way of a contempt petition. But in an execution petition, it still remains largely adversarial. Once again, as the decree holder, it is your responsibility, or it is your onus to find out methods, find out ways, legally permissible, of course, under the CPC, to try and execute the decree in the first place. Now, in this context, what are the modes of execution? Well, ultimately, how exactly do you enforce something? You enforce something under the threat of coercive action. Coercive action in the sense being coercive action within the paradigm or within the boundary of what is legally permissible. Now, obviously, this doesn't mean you will send muscle men to try and beat up the judgment debtor. That's obviously not something contemplated under the CPC. So therefore, what do? Well, you have multiple methods or modes available with you. The simplest mode is, of course, by actually trying to get the property delivered. Now, let's say in a case, the decree in your favor is not monetary in nature. You've sued somebody for specific performance. You've said somebody promised to, let's say, sell me this property, which is situated, let's say, in Lajpat Nagar in Delhi, property number 1/15, Lajpat Nagar. And the court decrees, yes, 1/15 Lajpat Nagar duly belongs to you. You are the legal owner. So when you try to execute this, the executing court is going to direct the judgment debtor to hand over that particular property to you. That is the most straightforward way of doing it. But now let's come back to the A versus B example. A wants to recover 75 lakhs. He has no business with any particular property of B. His claim has never been to get any property from B. He is only concerned with the money. Now, let's say B has a flat in a particular portion, in a particular area in Bombay, in a very tony area in Bombay. Now, therefore, to get the 75 lakhs, if B refuses to pay, A will ask the court concerned in Bombay to say, this A, B, C, D, E are the properties of B. Please attach these properties and sell the relevant property to ensure that my 75 lakhs is received from B by the means of attachment or execution through the court. Now, one extreme way of doing it, which we will come to in detail later, is by arrest and detention of the judgment debtor. We will come to this in detail. Effectively, from textually itself, what it refers to is, if the decree is not satisfied, you have the right to get the judgment debtor arrested and detained in civil prison. Though the interesting part of this is, though that's not mentioned in the overview, that you actually have to pay for the judgment debtor's maintenance when he or she is in prison. So what it means is, you need to deposit the charges which will be incurred by the state for keeping him or her in jail, which means possibly, you have to pay the jail authorities. It's not a massive amount, but yeah, you have to pay for the daily food, possibly a small proportion of the infrastructure in terms of, whatever is provided there, jail cells, etc., etc. So interestingly, under the CPC, you can send somebody to jail, but you have to pay for his or her stay in jail. Now, the other way, of course, is by appointment of a receiver. This sort of ties in with A and B, that if B refuses, or if the properties are in fact so multifarious, that you can actually ask for appointment of a court receiver, which is nothing but a person nominated by the court, who will then de facto and de jure be entitled to take over possession and control of these properties, and then deal with them in a way which will ensure satisfaction of the decree. Now, then, of course, there is the residuary power also available with the court, though that, of course, is rarely resorted to because of A to D being otherwise comprehensive mechanisms. Now, as I mentioned, arrest and detention is obviously one of the more extreme ways of getting it done. This is obviously applicable in the case of an individual judgment debtor. See, in the case of corporate entities, unless you are able to lift the corporate veil, which is obviously a significant task. It's not an easy task because of the entire notion of separate legal or corporate personality. Ultimately, when the individual concerned is unable to satisfy the decree, as I mentioned to you, you can ask for detention of that particular individual in civil prison. So this is as opposed to criminal imprisonment for, say, a criminal act or deed. Now, there are some preconditions which are attached to this. This is again more formalistic. We need not get into it in such detail at this stage. But again, this is important to read, and you will obviously get a more detailed understanding once you go through the other article. Now, one important aspect which is important to bear in mind is that the decree holder obviously has the method open to choose any particular way of going about it. Now, you can't tell the decree holder, first you do this, then you do that, then come to this method. The wide discretion is available to the decree holder. But please bear in mind that there is some case law, which we will come to, which has somewhat diluted this, because evidently detention of a person is a very extreme step because of the deprivation of personal liberty, which occasions as a result thereof. So when we come to it later, the general practice which is followed by the courts nowadays is to ensure that all other avenues possible to get the decree realized have been exhausted or satisfied before formal detention in civil prison can be ordered. Now, please bear in mind there are certain exceptions to the class of persons who cannot be so proceeded against. So, the CPC actually provides the sort of satisfaction, say, to judicial officers, to women, to certain members of legislative bodies, etc., etc. And of course, there is also a limit which, in today's contemporary parlance, is basically ineffective, which says the decretal amount does not exceed rupees 2,000. Now, as is unfortunately the case with most of our legislations, they are not really updated with the passage of time. So something like this seems ludicrous now, because who's even going to bother filing a suit for a debt below rupees 2,000? So that is as far as the exceptions are concerned. But now this is important. So as I mentioned to you, see, ultimately the courts have stepped in to put some fetters on the right to detain somebody. See, because ultimately, when somebody is unable to pay, there may be legitimate reasons. The person may be bankrupt, for instance. Now, obviously, bankruptcy should not be used as a cloak or a cover to be able to defeat the decree, even though the person otherwise has the means. That obviously is unacceptable. But if there is a legitimate ground, when there is absolute, complete penury, complete bankruptcy, then there was this judicial notion which came about, and rightly so, that if somebody is actually unable to pay, not because he or she is resisting the effect of the decree, but that there is actually a genuine case of penury, then this should not be resorted to without, let's say, any other understanding, or without any other finding by the court concerned that there is not only an omission to pay, but an attitude of refusal on demand. Now, therefore, in practical circumstances, rarely do executing courts directly permit you to invoke the detention paradigm. Usually, you will be practically required to first at least try and establish that there are certain properties, etc., which are available with the judgment debtor, and that he or she has, let's say, transferred them illegally, specifically to defeat your decree. Let's say someone transfers property through a gift deed to a son or a daughter, and then says, look, I am left with nothing. That obviously is something which will possibly come within the purview of an attitude of disowning the obligation under the decree. But practically, please remember, it is usually not a good strategy to directly ask for civil imprisonment, because executing courts are loath to do so unless you have done at least some sort of an exercise prior to that in terms of trying to discover or determine the assets which are available to the counterparty. Now, obviously, for detention, considering it's a serious step, there have to be orders which have to be specifically recorded, demonstrating satisfaction with the benchmark required for ordering of that particular detention. So, civil detention is in fact a very interesting area of execution proceedings. There is not much, in fact, which has been written on it, and not much which has been written on it in the sense of the evolution of, say, the understanding of personal liberty, etc., etc. But again, this debate has somewhat come up into the limelight, though not in the exact terms, in the sense of the kind of economic offenses we have seen in the last 1 decade, and how certain businesses which have otherwise collapsed. Now, the reason for the collapse, of course, is a matter of contestation. But now you have the promoters or the directors being sought to be roped in the sense of personal culpability. So, I mean, as a hat tip to all of you, this is an area of the law which I think doesn't have enough literature on it. So for anyone who's actually interested in churning out a good article, this is actually something which is of significant interest and does not have sufficient literature on it in the contemporary day and age. Now, moving back to, again, let's say, less controversial modes of execution. As I mentioned, the simplest way of doing it is to actually try and attach the particular property of the judgment debtor, and then obviously try and put it to sale. So if B refuses to pay, but B has, say, an apartment in a very tony area of Bombay or Mumbai, you will essentially request the court in the concerned city to attach that particular property and to put it to sale, usually through auction, wherein people will come, purchase that property, and deposit that money in court. And pursuant to that deposit, you as the decree holder will then be able to withdraw that money from the court. So that is a relatively straightforward mechanism. But if you look at the relevant order and the relevant sections, there is a detailed methodology which is prescribed in terms of going about this attachment and then going about the sale in terms of what is the method for sale, etc., etc. That again is something you can look at in terms of the specifics. Now, ultimately, obviously, when an attachment is done, the court must satisfy itself that the property is something which has an attachable interest. Now, to give you an example, we may have a very tony flat in Bombay, but what if that flat is already mortgaged to a financial institution, right? So, for practical purposes, B remains the owner, but a bank has a first charge on that property. So therefore, effectively, that attachable interest doesn't really exist till the bank's obligation or till the bank's dues have been cleared by B. Now, therefore, that has to be something which has to be specifically determined by the court enforcing the decree, that the attachable interest must be there. And interestingly, you will find case law wherein the decree holder may have supplied wrong information in the sense of a property, which is then proceeded to be attached by the court, and subsequently the party which actually owns that property comes up and says, look, I have nothing to do with the judgment debtor. This decree holders had my property attached by the court. I have been put through harassment. And there are cases where the courts have then imposed a significant cost on the decree holder for having put the judgment debtor to inconvenience. So please bear in mind that the decree holder has to be careful and with the necessary due diligence before indiscriminately trying to attach properties where B may not really have an interest in the strict sense. Now, obviously, there are it's not just property. There may be attachment orders which may be, let's say, made qua salary. Somebody may be having, let's say, a salary account. He or she may be paid salary by a particular entity. You can seek to attach the salary. Then the concerned company will then be told to deposit the component of the salary, which is actually attachable, because there are certain parameters for attachment also. And 2/3, 1/3, etc. can then be asked to be deposited before the court concerned on a recurring basis so that your decree is ultimately satisfied. Now, there are obviously certain limitations, as in the case of taxation also in our country, when it comes to agriculturalists. So therefore, that also please bear in mind. This is again dealt with in detail in the order concerned, wherein for certain stages, for certain elements such as growing crop, etc., there are certain limitations with regard to enforcement. Now, naturally, with the growth of commercial litigation, commercial transactions, etc., this doesn't really come up so much anymore. Though when the stage when the CPC was enacted, obviously, the significant portion of the economy was based or revolved around agriculture, as also the transactions. And therefore, this was obviously a big aspect to be kept in mind. So it's still relevant, but not to the extent which it was earlier. Now, as I mentioned, once attachment takes place, the necessary corollary is that you have the sale of the same. And please bear in mind, if the property is large, for instance, let's say your decree says 75 lakhs. Now, there is a Tony apartment which B enjoys. And for some reason, let's say the apartment is a duplex or by any means can be split. And the entire apartment does not have to be sold. Or let's say he has 2 studio apartments, one next to each other, each say worth 1 crore each. Then the court, even though it attaches both to ensure that he doesn't dissipate them, may ultimately decide to actually recover 75 lakhs. It's only necessary to sell one of them. So that again is a matter of, say, semantics. It's a matter of understanding what are the requirements of that particular case. And again, it's very case specific. Now, what exactly can be attached in terms of the property? Well, lands, houses, goods, money, banknotes, checks, basically everything under the sun which has some form of commercial value and which belongs to the judgment debtor can be subjected to the process of attachment. Though please bear in mind, there is some controversy in the sense of whether certain amounts such as pension, gratuity, etc. can be attached. The general tenor is they can be in certain situations, but there is some conflicting case law to that extent. So that is something which you can take a look at, whether retirement benefits per se are subject to attachment. That there's some controversy and there are certain exceptions. That is something which I would recommend you go through in your spare time. Now, very interesting element of enforcement, and please bear this in mind because this comes relatively frequently. Let's say B passes away before the decree attains finality. Now, when A seeks to execute, he will obviously implead all the legal representatives of B. But see, ultimately, we don't believe in a feudal system, where the son or the daughter is necessarily liable for the sins of the father, to put it in that dramatic sense. So, ex facie, you can't rope in a legal representative to execute the decree unless you demonstrate that the legal representative concerned actually benefited from the estate of the deceased judgment debtor. Now, to give you an example, before B passes away, he executes a will. Now, B has a son and a daughter. Now, B and the son have had strained relations for a long period of time. And therefore, in his will, B completely disowns the son and says, nothing will I give to the son. Everything he has, he writes in the name of his daughter. So, in this situation, B's son cannot be proceeded against in execution proceedings for the enforcement of the decree against B, because B's son has not received anything from B, which is then attachable qua B's obligations. As far as the daughter is concerned, she is then liable to the extent of the estate. So let's say B had only one flat which cost 50 lakh rupees, the value of which is 50 lakhs. So if he transferred that one solitary asset to his daughter will be liable to the extent of the asset value which to transfer to her. So if only, let's say, an amount of 50 lakhs was transferred to her, she is liable qua the extent of 50 lakhs. If an amount of, say, 1.5 crores was transferred to her, then she is liable to the extent of the entire 75 lakh decree, because she is received over and above that decree in terms of the estate which has been bequeathed to her by B. Now, well, there are certain obviously differences when it comes to ancestral property, etc. Because that, again, as I mentioned, in the case of a joint property family also, a joint Hindu family also, there will be certain cases where there is a vesting of a particular property on account of being part of that particular joint Hindu family. But effectively, there are certain more complications when it comes to ancestral property. For instance, even if there is a partition of the property, and after the partition, the son of B, if let's say there was a Hindu undivided family, has received his own particular share, but ultimately he derives it on account of his membership in the Hindu undivided family, which comes across because of his father B being a part of that particular family. Therefore, if the suit was pending prior to the partition, then even post the partition, to that extent, then the property can be sought to be attached and sold. Now, again, these are elements which will come into being, which you can look into in detail in terms of the individual sections and the orders. Now, the general principles we have already gone through when we started with the lecture, in terms of the execution of the decree, in terms of what is the relevant court, what is the court having competency, etc., etc. Now, please remember one important element, which is this. All questions arising between the parties to the suit and the decree shall be determined by the court while executing the decree and not by a separate suit. What this means is, for instance, now, if you were parties to a suit, now the execution is filed qua decree. This is to ensure that the judgment debtor does not get the chance to initiate an independent litigation to try and defeat the decree. So what this essentially means is, let's say now when the execution is ongoing, the judgment debtor suddenly wakes up and in a way to defeat the decree has a great idea. His lawyer tells him, now file a suit against the decree holder. He tells B, file a suit against A now, even though there was no counterclaim by B, there was no other claim by B. Today the lawyer tells him, file a suit against A saying that A did something to you, there was some cheating, or there was, let's say, some loss of reputation, defamation, etc. Pay me 1 crore rupees. Now, B may try to tell the executing court, oh, look, I have to yet to recover 1 crore from A, therefore don't proceed against me. But that is the kind of litigation which is sought to be objected to, or sought to be curtailed by this provision, whereby whatever defense you may have, which specifically arises out of that particular litigation and between the same parties, you are required to articulate before the executing court and not by way of a separate suit. Now, also bear in mind that that when a decree is passed against a party as a legal representative of a deceased person, and decree is for payment of money, then again it may be executed by attachment and sale of any such property. This is in a case where the LR is brought on record prior to the decree actually being passed. And therefore, the decree itself will be against the LR concern. Though again, here also there are similar provisions in the sense of liability. Now, where immovable property has been sold by the court, then obviously the sale shall be absolute. This is to ensure that, let's say, a third person comes and buys a property in an auction. Let's say tomorrow he or she is subjected to harassment by me, who then tries to file all sorts of litigation to try and have that auction or attachment set aside. Therefore, this gives finality and security of, let's say, title to the third party, which has actually purchased that property through the means of auction. Now, also, as I mentioned to you, one important aspect is that this has to be formally transferred by the court, which actually passed the decree in which the execution is sought, so that in future there is no controversy in relation to what is the nature of the decree and what is actually sought to be enforced thereunder. Now, this is why you must formally ask from a certificate from the original court, and you can't directly say run to Bombay with the decree and say, hey, please execute this for me. There is a formal process which is required to be undertaken by the executing court. When we come to arbitration, we will see this is something which doesn't apply to arbitration proceedings. An award you can directly seek to enforce before any competent court where the property of the judgment debtor may be situated. We'll come to that in detail when we come to arbitration specifically. Now, one last very, very crucial aspect which you need to remember: an executing court cannot go behind the decree. What does this mean? See, the role and scope of an executing court is very, very limited. Before the executing court, you can't seek to render the proceedings as some sort of a rehearing of the original case or some sort of an appellate forum where you try to then again come about and try to revisit the merits of the decree which has been passed against you. So all this means is that the executing court can't at the stage of execution say, oh, I think it's very unfair that B has been subjected to 75 lakh rupees. Let me make it 40 lakh rupees. The executing court can't say, oh, I don't think, now I am independently reviewing the merits, I don't think there was actually any contract between A and B. This decree has been passed, in a wrong fashion. These are elements which the executing court cannot get into. Its scope is very limited. Read the decree as it is, understand the decree as it is, execute the decree as it is. Though it has the power to interpret a decree. Let's say in a decree, a certain formulation or a certain relief is a little vague. Obviously, the executing court must have the power to interpret it within the meaning of the applicable law and possibly the transaction between the parties. But the power to interpret can by no means be extended to make out an entirely new decree which no parties actually ever contemplated and which the court which actually passed the decree never really had in mind. There are certain exceptions in case of very, very root questions or jurisdictional questions. For instance, where a decree has been passed by a court without jurisdiction. Now, this is fundamental because if there was no jurisdiction, then the decree itself is, problematic. Though over the years, this also has been whittled down because many elements of jurisdiction, etc., it has now been held are not really the kind which will go to the root of the matter. And there are certain judgments which say that even if there was a jurisdictional issue, it should have been raised before the appellate forum. Therefore, the lack of raising it before an appellate forum is in some way operating as an estoppel. There are contrary views on this. This is still a very controversial area as to what are these jurisdictional elements which can actually be said to go to the extent of defeating the right to be able to enforce a decree. Now, one of the aspects which is considered, say, is territorial jurisdiction. So if, let's say, you are able to demonstrate that the suit was, let's say, filed in this particular case, let's say in Jammu and Kashmir. Now, tomorrow B is able to, let's say, explain, particularly in the case of an ex parte decree, that look, the Jammu and Kashmir, the court had absolutely no jurisdiction. Nothing happened in J&K. Contract wasn't signed there. None of us reside there. No payments were made there. The transaction didn't take place there. So possibly this is something which we can then try and utilize to defeat the decree in the execution proceedings. Now, as I mentioned to you, there is again a lot of case law which has subsequently interpreted this jurisdictional paradigm. So it's not as simple as saying that every jurisdictional issue can be used to defeat a decree. A distinction has been drawn between, let's say, something which is fundamental and something which is not. For instance, there is a distinction that even though an unregistered firm under Section 69(2) is not supposed to be able to maintain proceedings in its own name, but this has been held to be not something which is so fundamental to be able to defeat a decree. So again, this is a little subjective. This is something you will have to take into account on a on a case-to-case basis. Now, one also important aspect is, see, it's not as if an execution proceeding is a walkover. It's not that you file the execution and there is absolutely no defense that the judgment debtor can take up. Now, there can be objections by parties. For one, objection can be by the judgment debtor saying there was no jurisdiction in the court which passed the decree. Therefore, it is not executable. Third parties may come, as I mentioned to you in the case of wrongful attachment. Third parties may come file objections to say, this is my property. I purchased it from B 10 years back, much before the decree got over. I paid valuable consideration for it. I am a bona fide purchaser. So therefore, in many execution proceedings, you will see execution proceedings get bogged down significantly because multifarious objections are filed by concerned parties seeking that there should be no execution which is proceeded against because of the multifarious reasons, some of which I mentioned to you above. Now, there are, of course, when it comes to delivery of immovable properties, there are certain specifics in terms of how it is to be undertaken. I'm not getting into that in detail now. That is something which you can go into the details of when you look at the particular orders or when you look at the particular provisions. There are a lot of these minute exceptions, armed forces, personnel, etc., etc. Now, naturally, when it comes to execution of foreign decrees also, there is a certain categorization under the CPC, which essentially recognizes foreign decrees and of reciprocating states, and also lays down the mechanisms or the specific requirements which have to be met by the decree holder when he or she seeks enforcement of a foreign decree. For instance, the requisite, the stamp or the requisite formalities from the court concerned, possibly a validation certificate from the embassy concerned, etc., etc., depending on the requirements which you might be required to meet. Again, this is dealt with in detail in the specific formulations under the requisite order, Order 21. Now, as I already mentioned when we spoke about appeals, the executing court may, for a particular period of time, grant time to the appellant to file a appeal if it finds that, for instance, the limitation period for filing an appeal, etc., is still available to the appellant. But this does not stop the executing court from having the power to issue certain interim orders so as to ensure that the assets available with the judgment debtor are not dissipated in the meantime to try and defeat the decree. Now, there may also be cases of, say, multifarious let's say, decree holders against B. Now, let's say B got into a lot of trouble in that particular period. Many people filed cases. Now, D, E, and F also get decrees against B for varying amounts, 20 lakhs, 50 lakhs, 1 crore, 1.5 crore. So, obviously, all of them also have a right to ensure that, the property in question is distributed in a rateable manner. So, in a pro rata distribution, the properties will then be distributed amongst all the decree holders. Again, this is commonsensical. Now, again, there is the obviously execution of a decree, a straightforward decree in the case of specific performance. So there, like I mentioned, what the avenue open, the straightforward avenue open is to ensure that the property concerned is then transferred into your name, including by having it registered by the competent sub-registrar through an officer of the court if the judgment debtor or D refuses to cooperate in this regard. Now, there is also an element of a preliminary decree and a final decree in the case of partition suits. And a preliminary decree in this case is only a formulation of what is the rights of the parties under the general terms. But then the final decree is the one which will possibly then, the partition the property as such, either by meets and bounds, or by, let's say, a separate possession, or by, sale of the property, and then pro rata distribution in terms of the rights of the parties which exist to them under the particular decree. Now, this again, as I mentioned, is the specifics of it. There is a completely different regime when it comes to execution for restitution of conjugal rights. This is again a very controversial area of the law. wherein a spouse, a aggrieved spouse, or a spouse who's living separately can effectively be directed to continue to live with the estranged spouse under certain circumstances. But the execution of this, obviously, because of the controversial elements involved of forcing somebody to physically reside with somebody else, is obviously something which is not subjected to the strict rigor of execution or enforcement. And this is something which is then the execution itself is more in the sense of the consequences which might arise in the sense of approving of desertion, etc., etc. Now, do bear in mind the concept of restitution of conjugal rights itself has been an area of significant controversy, and there are petitions pending in various courts challenging the constitutional validity itself of a provision which provides for restitution of conjugal rights. Now, of course, then there are these other elements in the sense of how to ensure early disposal of execution proceedings. This is obviously in the sense of ensuring that there are no stays which have been passed by appellate forums, as we mentioned, and generally the process which can be followed by the court concerned to ensure that the execution is proceeded with. Now, please bear in mind one very important aspect, that execution of decrees also is subject to limitation. Now, a lot of people think that once you have a decree in your favor, then, at any point in time, let's say after a decade, after a century, etc., etc., you can basically try and make a particular decree executable. But please bear in mind that is not the case. Under the Limitation Act, various limitation periods are provided for actually executing a decree. To give you the example of the most straightforward case, under the Limitation Act, if you are asking for execution of a decree other than a decree of mandatory injunction, let's say take this case between A and B, this is a purely monetary decree, then the limitation for A to enforce the decree against B is when the decree actually becomes enforceable in the sense of it attaining finality. Now, from that date, A has 12 years to execute the decree. So please bear in mind, it's not as if you have a decree and 25 years later you can go and ask for execution of the decree, because no matter how unfair it seems, even if you have a decree and you've not acted upon it, let's say within this 12 years as applicable to the present scenario, you will then lose your right to execute that decree for all times to come. So this is also something you need to bear in mind, which has not been dealt with in the present overview. So this is basically a broad overview in the sense of how exactly do you enforce a civil decree. Please read this in conjunction with the right or the power of contempt, which will be applicable in the case of certain other cases. And in multiple cases, the forums concerned, which actually operate under the particular, let's say, special legislations, will then have their own methodology of enforcement or execution, which powers will be rendered to them or which powers will be bestowed upon them in terms of the specific statute under which they are birthed and under which they operate. So this is as far as the concept of enforcement is concerned. And in fact, it's not paid enough attention to, but it is obviously very critical, because this is really where the money lies. Ultimately, after that entire adjudication, this is where you are able to essentially recoup or effectively validate your rights in concrete terms. So that's as far as today's lecture is concerned. So if there are any questions, please you can shoot them to me in the chat box. And now, therefore, see, ultimately we have arrived at, let's say, the culmination of this entire process, primarily from the perspective of, say, a civil suit or a civil litigation. But this also, to a large extent, covers most of the rigmaroles of civil litigation in general. For instance, now, if you were prosecuting a case before the NCLT, under the IBC, the NCLT would have given you an order. You would have possibly gone against that order before the NCLT in appeal. NCLT would have decided either way. Then you would have possibly gone before the Supreme Court. Supreme Court would have decided either way. Ultimately, you would have sought enforcement of that particular order or a decree or whatever it is passed by the NCLT. Same is the case in a writ proceeding. You would have gone before a writ court, gotten a judgment, possibly gone in appeal in LPA, letters patent appeal, before the appellate forum, the division bench, then possibly tried your luck in the Supreme Court. So again, there is a finality. So once you've got that decree in your favor, or the other side's gotten, let's say, an order against you, a writ order against you, then that is then again subject to contempt action. So usually in writ proceedings, the other side is the government. And in almost all cases, the private party is the one which is filing the case. So therefore, the private party concerned will then file a contempt petition against the counterparty, which is in most cases the state or a government department. So this essentially applies, what we've dealt with so far applies primarily to almost all forms of civil litigation. And therefore, this is essentially the culmination of this long process which we've undertaken right from day one when we've met the client. So this is essentially what is, in a nutshell, the entire lifespan of a civil litigation in the country, right from its birth all the way up to the culmination in the form of the enforcement of the decree. Now, since we've come through all of this, effectively, we should now have started and moved on to arbitration towards the fag end. But before that, there are a couple of things which I want to deal with. Most importantly, the regime under the Commercial Courts Act. Now, why the Commercial Courts Act is important to understand is because it seeks to bring about a cultural change in the way civil litigation is prosecuted in the country. And because of the wide definition of what constitutes a commercial dispute, coupled with the low pecuniary value which is prescribed for determining a subject matter as a commercial dispute, if any one of you who actually enters into mainstream litigation in the future will inevitably have to reckon with this procedure of adjudication under the Commercial Courts Act, which marks a significant departure from the standard procedure under the CPC under many parameters. So therefore, I want to devote one lecture to the Commercial Courts Act specifically and the new regime which it brings into effect. Now, I'll upload a PowerPoint presentation which I had made for a webinar, which will deal with almost all elements of the controversy. I will also leave a link to the session itself. It's a very long session, but some 2.5 hours. There was a lot of questioning. There was also a person who was a co-panelist, Honorable Judge. So therefore, it's obviously extremely lengthy. But for those of you who want like a very detailed look at what commercial courts actually constitute in terms of their effect and in terms of the specialized regime they bring in, please refer to that. But I will anyways be sharing the PowerPoint presentation, which I prepared for that. And based on that, very quickly, we will run through what the Commercial Courts Act expects you to do and why as lawyers, you must be aware of those specialized requirements whenever you approach a commercial litigation. So that is it from me for today. So any questions, we can deal with those. Otherwise, we can call it a day. So if anybody is typing out a very long question, you can just type yes or something. Otherwise, if there are no questions in the next 5 seconds, then I think we'll call it a day for today. Right. So I will see you guys then tomorrow evening, and I will upload the reading material as discussed. All right. Thanks a lot. Bye-bye.